I have filed an application yesterday.
Why? What difficulty is he having? Huh? Who is your senior? What is your name? Mrs. S. Borpatra Gohain, Learned Counsel for the petitioner, prays for adjournment as her senior. Mr. Dr. R.C. Borpatra Gohain is not, is unread. List the matter when? When do you want it listed? 29? Today is what date? 29th is Tuesday. Why Tuesday? Monday? He's going to have a headache till Monday or something? No, Monday is a motion day. This is a motion. No, Monday. 28th. List the matter on Monday. That's right. Did you participate? Did the petitioner participate in the tender? First of November. And it's 28.
May it please the Lordship. Lordship, I beg to list one pending contempt petition, Lordship, on 12th of November.
Okay.
Of like,
Item number. Taken up. How much is paying?
Okay. For what? Okay. Okay. Not Monday? Monday? Okay, Wednesday also, how does it matter? Wednesday, it doesn't matter. P9. Then give a date someday.
I think 44 draws.
Mr. K. Dekha, Learned Counsel for the petitioner, submits that he has received instructions to withdraw the writ petition. Mr. P. Nayak appears for
GFC.
the GFC. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn.
Release for motion item 1.
Heard, Mr. K. Uddin, Learned Counsel for the petitioner, who submits that the bills of the petitioner have not been paid in terms of the order dated 26/7/23 passed in WPC 6482 of 22. Issue notice returnable in 5 weeks. Petitioner to take steps for service of notice upon the respondent by registered post within 3 days. This is the matter after 5 weeks.
Item 2.
So, who is for the fishery? Let the fishery people.
Item 3.
He has not completed the contract.
Completed.
Completed.
Surrender.
You surrendered the work. So are you entitled to the amount?
Yes, my lord, here admission, my lord.
No,
Yes, number-
the admission is a different thing.
But we will
Anyway, we'll issue notice, let you obtain
not
instruction.
by object and maintainability law.
Okay.
2015 matter.
Oh, 2015 matter.
Yes.
When did you surrender the matter? When did you surrender the case?
2019.
2019.
5 years. The recently Supreme Court passed on the law. Money claim before it reached no law. It is not maintainable.
If it's an admitted amount, then it's.
Consider a delay law. 2015 matter, he is not even allowed to go to the lower court law.
No. You see, but the Tamsher Ali is there. Full bench judgment of this court is there.
Considerably is a case not when prior to 2010 law.
Maybe,
And
maybe,
what-
but the decision is still binding upon. When you can take care of claims which are beyond the limitation period of that area, of that period, why can't you take care of it now?
There lots of one full bench judgment is case.
2015, okay, 19 you have surrendered the thing. And then how come you have come here?
We have communicated with them, we have given many representations. Lastly, on we filed a representation 2/3/2024.
Okay, we issue notice keeping it open, right? Heard, Mr. G. Pathak, learned counsel for the petitioner, who submits that the petitioner was issued two separate work orders with estimates being 85,99,000 and 1,92,49,400. The petitioner completed approximately 40% and 30% of the work respectively. And thereafter, he surrendered the work in the year 2019. Full stop. The petitioner's counsel submits that the petitioner should be paid his due amount, his contractual dues for the 40% and 30% of the work done. Full stop. Issue notice returnable in 5 weeks. Mr. Yes, Mr.
Lordship, I am for 3, 4 and 6 and Upadhyaya.
And Upadhyay accept notice on behalf of respondent number
3, 4 and 6.
3, 4 and 6, while Mr. P. Nayak accept notice on behalf of
I am appearing for 2 Lordship.
2. Mr. K. Gogoi appears for respondent number 1. Full stop. The counsel for the respondents submit that the writ petition is not maintainable as the petition has been filed 6 years after, no, 5 years after the contract has been surrendered by the petition. This is the matter after 5 weeks. The maintainability of the writ petition shall be kept open in view of the judgment of the Supreme Court in the case of.
Lordship, I am having a live law citation.
So just give me the citation then.
Yes, the Director of Agriculture and others versus M.S. Ramachandran.
MS Ramachandra,
Ramachandran,
Ramachandran,
yes. And live law citation is 2023,
live law,
live law SC
S,
220.
live law 2023,
SC 220.
SC 220.
And therefore,
It appears that this is, you have surrendered the matter in 2019.
madam, I have made communication with them, they are not.
Communication does not, does not, does not, does not give you a fresh cause of action. Why don't you communicate for the next 20 years in that case? Because there are Supreme Court judgments to that effect.
They communicate, they have not.
You should communicate and within that limitation period, you should file. And in this case, you see, this is not a case you have completed your contract. This is a case where you have surrendered the contract.
Able to pay me.
Okay, anyway,
The amount. Amount.
anyways. Next, yes, we issue notice,
Lordship.
Mister. Here, Rashid, learn counsel for the petitioner who submits that the petitioner's contractual dues amounting to rupees 19,67,409 has not been paid. Issue notice returnable in 5 weeks. Ms. M.D. Bora accepts notice on behalf of,
That's number one.
respondent number 1, while Ms. D. Jain accepts notice on behalf of
3, 4, and 5.
respondents number 3, 4, and 5. Who is for 2? Mr. P. Nayak accepts notice on behalf of respondent number 2. This is a matter of the 5 weeks to enable the respondents to file affidavit.
Of license.
Can it be taken with?
Okay, list the matter along with
1680.
similar matters. What do you mean similar matters? Huh? No need, no need,
17 matter.
no need.
I think 5.
So, appeal not decided.
Dispose of the.
So appeal should be decided within how much period? A month. Right. Heard, Mr. A.M. Khan, learned counsel for the petitioner, who submits that the petitioner's fair price shop was cancelled. When was it cancelled? Cancelled on 5/1/2024. And despite the petitioner filing an appeal on 7/2/2024 before the respondent number 2, the same has not been disposed of till date. Mr. K. Gogoi, appearing for the respondent number
Say 1 to 6, Lordship.
1 to 6,
1 to 7, Lordship.
1 to 7, submits that the writ petition can be disposed of if a direction is issued to the respondent number 2 to dispose of the petitioner's appeal. Full stop. On considering the fact that the respondent number 2 has not disposed of the petitioner's appeal as submitted by the petitioner's counsel, the respondent number 2 is directed to dispose of the petitioner's appeal within 1 month from the date of receipt of a certified copy disorder. Full stop. In the event the appeal has already been disposed of, the respondent number 2 shall communicate the decision taken to the petitioner. There is petition accordingly. No need, I've already said that, no?
That being added to.
Yes. He wants adjustment of his revenue.
Lordship. He wants, we are processing, Lordship, then also he is.
Huh?
We have processed his Lordship,
Ah.
but then also he wants, I think he is seeking disposal of this.
Representation. So you decide whether you are allowing it or not. That's all.
We are allowing, Lordship.
You're allowing.
We are allowing, it is our general policy that we allow it.
Okay. Okay. But you,
For
the
for sake of-
decision is not forthcoming. That's the problem. You're allowing, but if you allow it after 20 years, to no point.
No.
He wants it now.
We have shortage of staff, Lordship, so we process it around 3, 4 months, but he is approaching, Lordship.
He's in a hurry.
He is in hurry.
Okay. Heard, Mr. M.K. Hussain, learned counsel for the petitioner, who submits that the petitioner was settled with the Garalu Meen Mahal under Marigaon district for 7 years, with effect from 1/4/22 to 31/3/22. Full stop. The petitioner's counsel submits that though the final settlement order of the Meen Mahal, Garalu Meen Mahal, was issued on 5/11/22 in favor of the petitioner, the possession of the Meen Mahal had been handed over to the petitioner only on 5/11/22 instead of 1/4/22. Full stop. The petitioner's counsel submits that the petitioner had accordingly submitted a representation dated
19 page 21.
19/2/2024, addressed to the respondent number Respondent number 3. Praying that the saying that there should be adjustment of the revenue payable by the petitioner to the fishery department, AFDC, to the
Corporation.
AFDC for 218 days from 1/4/22 to 5/11/22 due to the late delivery of possession of the Myanmar. However, the same has not been decided till date. Full stop. Mr. P. Sharma, learned counsel for the AFDC, submits that the petitioner's representation is under process and the decision will be taken shortly. Full stop. Keeping in view the fact that the petitioner's representation was submitted on 19/2/2024, this court is of the view that the respondent number two or three, respondent number three that should take the decision at the earliest. And at the earliest, with regard to the prayer made in the petitioner's representation. Full stop. Accordingly, the respondent number two shall take a decision on the same within a period of 1 month from the date of receipt of a copy of this order and communicate the decision to the petitioner thereafter. Said petition is accordingly disposed of. Yes, what is your name? Mr. A. Hussain, learned counsel for the petitioner, submits that the vehicle hire charges of the petitioner amounting to rupees 39,33,545 has not been paid. Issue notice returnable in 5 weeks. Mr. K. Gogoi accepts notice on behalf of all the respondents. This is the matter after 5 weeks to enable the respondents to file their affidavit. Yes, madam. When were you told to stop construction? This is your writ petition, madam. You should be knowing the facts, the tip of your fingers. I know, my question is, when were you told to stop construction? When, madam, I didn't say who. Please know the facts. List them, as the petitioner is unaware of the facts of the case, list the matter after. When were you told to stop the construction?
It was under the section of the Municipal Act.
When?
It was my lord, 2020.
20, and you have come now.
But thereafter I find representation my lord again and again for the authority. That should be kindly soon. The representation my lord. In 2021, election, my lord, 7 series.
And the contract was awarded to you when?
It was my lord it was in the year, my lord, 2020.
20.
Yes, sir.
And you completed 60% of the work in 20.
20, yes.
And you were told to stop work in 20. Is it? Verbal,
Thereafter, I find the-
verbally.
Verbally. I categorically stated like.
Categorically, you can state anything. Because no one knows.
I have completed and
Is there any, what is the amount of work, the estimated amount?
1 through 1990 last.
Is there any contract agreement?
Yes, madam.
Wait, show me the contract. Is there any arbitration clause in the contract agreement?
That contract is not, but my lord.
Mr. Counsel, there is a query. Whether there's an arbitration clause in the contract agreement.
My lord, page 15, already payment was made, 1,69,000, madam.
Maybe, so what?
They completed 60% work, madam.
Please answer the question.
I check, madam.
It's not like I'm asking you what you're wearing, you're telling me what you have eaten today.
Yes,
That's a
there is
different thing.
contract, madam.
Huh?
There
Yeah.
is-
There is a contract agreement, whether there's an arbitration clause. Right. Heard, Mr. Deodin, who submits that the petitioners have not paid, that the respondents have not paid the contractual dues of the petitioner amounting to rupees 40,70,102. Full stop. Next para. The petitioner's counsel submits that a contract for construction work was awarded to the petitioner in the year 2020, and the petitioner has completed 60% of the work. However, due to a verbal order given by whom? Given by whom? Is the minister a party here? Then where is that? Minister, which minister? Which minister has given you the verbal order?
Minister of Parimal Development Government.
Huh?
Parimal.
However, due to the verbal order given by Mr. Parimal Shukla Baidia, on Minister of Environment and Forests, Fisheries, Excise Department, Government of Assam, what have I said? However, due to to stop further construction of the contract work, the petitioner had stopped his contract work in the year 2020 itself. Full stop. He submits that the contractual dues payable to the petitioner is an admitted amount. Is it admitted? Where?
Page. Page.
Page 12.
It will work minor. Rupees 1,299,000.
Mr. Council, this is an acceptance of your bid. This is not acceptance of your bill. There's a difference between bid and bill. Where is the admission that you have completed 60% of the work?
Question you can see, page 13. This is the amount madam been mentioned, and next question you can see, page.
This is, you see, page 13 is again asking you to proceed with the work.
15, page 15.
Page 15, yes.
Actually, is hereby recorded for an amount of rupees 50,70,000, 100. That amount is paid.
So this is the amount you're claiming. Correct?
No, this has been already paid. And that's the amount, the work has not been allowed to. How we.
Okay, so you have been paid, you have been paid 40 this much, but beyond that you have not been paid. What did I say in the very beginning? And the dues of the petitioner, except for rupees 40,70,10. Except for. He submits that the estimated amount of the contract work was 1,99,998. 1,99,99,998. Full stop. Next para. Issue notice. Returnable in 5 weeks. Miss MD Bora accept notice on behalf of
That's number one, madam.
requirement number 1. While, no, what about 2 and 3?
Lordship notice they to the PNOD may appear, my lord, BDO and.
No, managing director, house fed.
3 PNOD may appear, 2 notice may go, my lord. The petitioner will take steps, my lord, for two.
For three, who
PNRD may appear, block.
who
development.
is for PNRD?
S. Datta, lordship may record S. Datta.
As data accept notice on behalf of point number three. Petitioner takes steps for service of notice upon the respondent number two by registered post with AD within 3 days. Full stop. Next para. The petitioner shall produce the contract agreement made between the parties and point out whether there is any arbitration clause in the said agreement. This is the matter after filing.
Lordship SC, WMD may be reflected in the causes.
Registry to reflect SC,
WMD and PNRD.
WMD and PNRD in the causes.
I'm so deeply obliged.
Notice may be issued.
Is it required?
Yes, my lord.
Why?
Going to file affidavit, my lord, on behalf of respondent number 9 and 9, my lord.
Will you really file?
Yes, my lord.
When?
No, I didn't file. It is the first time, my lord, motion made.
I know, but are you really going to file?
Yes, my lord. I have already communicated to the Brahmaputra board, my lord.
Okay,
Yes,
very good.
Taken, my lord.
Huh?
Yeah, this is. This concern. I will listen.
Should be,
Lordship, we need to verify the liability statement.
Huh?
As the last column is missing
Where?
in the liability statement. Lordship, page number 27.
27.
Yes.
What is the last cover? Remarks?
No, Lordship, balance.
Balance is here. I've got. You've not got.
Still, your Lordship, we need to verify the statement.
You should give the complete document.
Yeah, last column.
No, what is to be done by the Brahmaputra board? What will they do?
my lord, as per instruction, I have been given that they are going to file affidavit. My lord. Yesterday also I talked with them.
Okay, let them file.
Yes.
Because you see, one thing, that affidavit will clear all the cases.
Yes, ma'am. Once affidavit will cover all the.
Will cover all the cases. Heard, mister? S.M. Barwa, learned counsel for the petitioner, who submits that the petitioner executed many works of construction under the Water Resource Department and under the State Public Works Department. No, this work is under what? PWD or what? Forget under the Water Resource Department only, huh? Only that. Under two schemes. However, the petitioner has not been paid his contractual dues amounting to rupees
7 lakhs.
7,83,89. Issue notice returnable in 4 weeks. Ms. D. Jane accepts notice on behalf of
Respondent number 2 to 7.
2 to 7. While Ms. A. Gayan accepts notice on behalf of
8 and 9.
8 and 9. What about 1?
One lordship, they have not properly lordship made party lordship. Only made
Ah,
party lordship. They have to,
which department?
nothing is there lordship.
Please read your respondent number 1. He is the secretary to the government of Assam. Which department? Huh? You have to file amendment. You have to file IA now. You have to file IA. You cannot do it by hand. You have to file IA, then you have got to file corrected cost title. Or-
Lordship, I have face petition.
I do not know. It depends upon him. He can take the long route or the short route.
উদ্যোগে ফেস ফাইল করে দেবো উদ্যোগে ফেস ফাইল করো আকৌ উদ্যোগে লিবার্টি ললো মানে
Yes, okay, best.
লসিকে Give a liberty to him.
Naturally, I have to give liberty to him. Heard Mr. S.M. Barwal as also for the petitioner, who submits that he may be allowed to withdraw the writ petition with liberty to file afresh. Prayers allowed. Writ petition dismissed as withdrawn, comma with liberty as petition.
Good night. Yeah, additional supplied material
When?
in the year 2021.
21. And when was the last supply that you made?
The last supply.
21 is.
20.
Okay, right. Heard Mr. M.R. Khandakar, learned counsel for the petitioner who submits that the petitioner submitted various supply materials for execution of flood protection works by the RCC Porcupines under the MGN REGA for the year 2020-2021 under the Bir Singh Jarwa Development Block, Dhubri District. However, the petitioner has not been paid the bills for bills amounting to rupees 2,45,99,874. Issue notice returnable in 5 weeks. Miss,
And Bora,
accept notice on behalf of
PNRD for respondent number 235-20.
235-20.
That's
Mr. A.K. Datta, accept notice on behalf of
That's number one.
1. What about 4 and 6? Yeah, for 4 and 6.
it.
5, what about 5?
6.
4 and 6. 4 and 6.
6 also.
G. Bokaliel, accept notice on behalf of respondent number 4 and 6.
4, only 4.
Only 4.
Only 4. 4. And what about 6? Achha, you, Miss Enbora, yes,
Yes,
please.
5 to 20.
5 to 20, yeah, 5 to 20. Miss Enbora for 5 to 20.
5 to 20.
2, 3, 5 to 20. Okay, then 1 to A.K. Datta and G. Bokaliel for respondent number 4. And this is a matter after 5 weeks to enable the respondent to file their affidavit.
Same.
Which item?
123, 20.
21,
22.
21, 23,
22, man.
22.
23.
And 28.
20.
Not 21.
22, 23, 20. Only amount is.
It's the same, everything is same. Actually, amount will be for 22. Amount will be 1,70,24,650. And for 23, it will be 4,53,20,329. And 28 will be 4,25,24,106. Huh?
Responded by your.
The respondents are same or not?
More or less number is.
No. We'll have to see number in the 50. Yeah. 22, 23, 28. In 22, Ms. N. Bora accepts notice on behalf of
2, 3, 5 to 13.
2, 3, 5 to 13. Others will remain the same. Huh? Then in 23,
2, 3, 5 to 18.
5 to 18. 2, 3, 5 to 18. Okay. Then 28,
28. Uh,
2, 3, 5 to 22.
3, 5 to
22.
22. Yes.
So in your fair price shop, no ration card holders has been tagged,
25%.
only 25. So you want more. Do you have any right to be tagged with more ration card holders? Huh?
As per the notification, they're taking. Nearby preference.
Huh?
As per the notification, they're taking. The next are P lots.
Page
There's 22 to 25.
25, 22, 25.
Those who have below 50, the super they are taking.
That, you see, but you're exempt from this. You're lucky. You cannot have your cake and eat it too. If you want this to have to apply to you, then your license will be cancelled, in fact, because you have got less than 50.
Earlier cancel, but
Huh?
earlier cancel was it. As per the establishment, the Nagpur High Court and the activity thermal responsibility, then will.
Correct. You cannot, you see, you cannot say that in one case you will not use this pen, but in another case you will use it. You cannot say that. Your fair price shop was cancelled on the ground that this notification provided that fair price shop was to have at least 50 card holders. So you had less than that, so it was cancelled. But you said that this cannot apply to you. This notification cannot apply to you because you're a handicapped person. Now, so the court that has been allowed. But now you are saying, no, notification should be applied to me insofar as I should be given 50 ration card holders. Okay. No case.
Earlier 39.
Huh?
Earlier 39 could work.
Earlier you had 39. Okay, earlier. Okay, earlier he had 39 ration card holders.
This case, I have to take instruction.
Okay. Okay. So, heard, mister? Heard, mister? DG. GG. GG. So, triple G. GG Gogoi. That counsel for the petitioner who submits that the petitioner had been running a fair price shop at Kathal Guri, Bamungaon, Dakho Khana since 1997. The petitioner is a specially abled person, about 80%, and 80%, first up. The Director of Food, Civil Supplies and Consumer Affairs had by letters dated 7/8/2021 and 12/7/2022 directed that tagging of ration card holders from fair price shops having 50 ration card holders or less should be made. Correct. With the nearest fair price shop having more than 50 ration card holders. The petitioner who was having 39 ration card holders. No, the license of the petitioner's fair price shop was cancelled as he had only 39 fair price shop. The 39 ration card holders. The petitioner challenged the same by way of WPC number 5274 of 2022. And this court, where is the order of this court? Page? Huh?
They have not annexed this order.
They must never have been told. After filing that.
Okay. And this court disposed of the same on the basis of the affidavit filed by the government of Assam, stating that persons belonging to the petitioner's category would be exempt from the purview of the decision to club the ration card holders under the PDA shop. Full stop. The same was done in terms of order, no, the WPC number 5274/2022 was disposed of by order dated 13/9/2022. I've got it here. Full stop. Next para. In view of the above facts, the petitioner's license as a fair price shop holder was restored. The grievance of the petitioner in this case is that he has been given, that his fair price shop, is that only 25 ration card holders have been tagged with his fair price shop and not the original 39 ration card holders. Issue notice returnable in 4 weeks. Mr. M. Chetty accepts notice on behalf of respondent number 227. While Mr.
DJ Council, Lordship, for one.
NJ Das,
DJ.
Das accepts notice on behalf of respondent number 1. That's all? This-
Yes, for number 8 is.
Why?
Maybe because.
Acha, your ration card holders are with. Acha, one thing you also right, he submits that the 14 ration card holders who originally were tagged with the petitioner's shop are now tagged with the fair price shop of the respondent number 8. Huh, right? Any right? Petitioner takes steps for service of notice upon the respondent number 8 by registered post with AD within 3 days. This is the matter after 4 weeks. Huh? 11, they said that 2, they made a mention this morning. They informed you. No, you are for which item?
11.
Who was the person who mentioned this morning? Huh? Oh, okay, we'll take it up. It was mentioned in the morning, that's why. Huh? Could be.
Some different.
For whom? RCC building to be constructed for whom?
This petition, construct the RCC building in their proper.
In their plot of land.
Yes, therefore. And regarding that, your worship, planning permit has been issued by the CMT. So for your worship, the NOC is concerned, in that regard, the CMC verbally asks them, in view of the communication letter that is annexure 7, issued by the joint secretary, that they needs to pay the forest royalties, which is contrary to the provisions. of
Who has asked for payment of forest royalty?
CMC.
GMCA,
The repetition.
GMDA,
Yes, GMC.
GMC.
CMC. The petitioner to pay the price royalty, which is contrary to the provisions laid down under SR minor minerals concession rule. And in this letter, your worship, similar applications were pending. The motion may kindly see annexure 7 and 8. Same, your worship. So in that.
Page.
Page number, your worship, is 72.
Yes.
And your further question start from.
Oh, you want to show the interim order part?
Yes, same.
Lordship, in similar matter, this issue has been taken care of, writ petition has been allowed, your lordship. Similar,
Para?
Page 7.
para 19, your lord. Thank you. Sir.
So then they're not liable to pay forest royalty. Correct? Huh?
That later had been set aside.
The letter, so what are you challenging here? The letter?
He sends a letter, 2/31/23.
That letter is set.
Anyway, so the letter dated this letter dated 2/3/23,
Has been set aside.
2013, 23. Okay, right. Heard Mr. P. Sharma, learned counsel for the petitioner, who submits that the petitioners were given power of attorney by the private respondents to construct a multi-storied RCC building in their plot of land. And accordingly, the petitioners were issued planning permit by the GMD authority. However, the GMC had directed the petitioners to pay the forest royalty in terms of the communication dated 2/3/2023 issued by the Joint Secretary to the Government of Assam, Mines and Minerals Department. Pusta. He submits that the direction given by the GMC to the petitioners to pay forest royalty should be set aside in view of the fact that the impugned communication dated 2/3/2023 issued by the Joint Secretary to the Government of Assam, Mines and Mineral Department, whereby the forest royalty was to be paid has been set aside by this court in WPC 4085/2024, Ahmad Deka and another versus State of Assam and 6 others. Mr. R. Gogoi appearing for the
Respond number 1 and 2, Your Lordship.
respondent number 1 and 2,
Forest Department.
comma, Mr. S. Bora for
6 and 7.
Huh?
6 and 7.
6 and 7, comma, Mr. K. Gogoi for respondent number 3, 4 and 5. And no, you're not there. Acha, you say and K. Gogoi, huh? For 3, 4 and 5. Submit that the petitioner's prayer in the writ petition for setting aside the communication dated 2/3/2023 issued by the respondent number 5 has to be allowed in view of the fact that this case is a covered matter in terms of the judgment and order passed in WPC 4085 of 2024. Next para. The operative portion of para 19 of the judgment and order dated 24/9/24 passed in WPC 4085/2024 is reproduced here in below as follows. In view of the fact that this case is a covered matter, comma, the impugned communication dated so issued by so is hereby set aside. That's all.
All right.
Then you give me just judgment of this after that. Huh?
Item 12.
Yeah. Huh? Judge Shakti?
No,
No.
Lordship. Dima Hassan.
Huh?
Dima Hassan.
Rima Hassan. Okay. Heard Miss. When did you finish the contract? Work order is which date?
20.
Huh?
2023.
Work order is of 23.
Yes, sir.
And have you completed the work? Okay, right. So why aren't you going for a civil suit? Is it admitted? Huh? Huh? I'm not, is it an admitted amount? Where? Page 11. No, Mr. This is acceptance of your tender. Where is the admission of your amount claimed? Page 13. Completion certificate, okay. Right, heard Mr. R. Sharma, learned counsel for the petitioner who submits that the petitioner was issued a work order in the year 2023 and he has completed the contract work. However, the petitioner has not been paid his dues amounting to rupees 999,932. 999,932. Issue notice returnable in 5 weeks. Ms. D. Jane accept notice on behalf of
3, 4, 5, and 6.
3, 4, 5, and 6, while Ms.
PW M Das.
M. Das accept notice on behalf of the PW. List the matter after 5 weeks to enable the respondents to file their affidavit.
Madam Patel, the better party to not payment of bills amount and liability is also claimed, page 20.
Page 20.
20. Last slide.
When did you do this work?
Because 19 the work was completed, therefore payment was also received by the department.
But this is for flood devastation 2017-18.
Yes.
How can it be 18-19?
The scheme was executed 18 last night.
Okay.
Similar matter speaks from 7, arising of the same call. So for today's matter,
Maybe 7, but each case is different.
Yes.
arising of the same work, but the list is there, one read petition, there are 50 read petitions, we have filed. Some are coming on Monday, what I train, 70, they are all waited to fix, become helpful. That's the, because today item number 13, 14, 15, 18, 19, 21, 26.
So we'll list all these data on 7. So we won't pass any order. Okay. On the prayer of the petitions council, list the matter on 7-11. So item number?
My lord, item 13, 14, 15, 18, 19, 21, and 26.
Okay.
Thank you.
License.
7-11.
Bye. Item 16. The admission is the 370.
When did you supply this water?
So during the period 1890.
This
Admission is the page 17 and lordship is page 20 or lordship will find.
for 17-18 you supplied water.
No, I supplied water in 1890.
89.
Page 17 for.
Okay, right. Heard, Mr.
No.
M. Das, counsel for the petitioner who submits that the petitioner's bill for supply of pure water for the year 2018-19 amounting to rupees 407,330 has not been paid. Issue notice returnable in 5 weeks. Mr. K. Gogoi accepts notice on behalf of all the respondents. List the matter 4 to 5 weeks to enable the respondents file their affidavit.
Item 17. Case 47 is the complication.
Where is the terms and conditions of the auction? Is there a term, is there any term for cancellation of the auction notice for the auction?
They have already extended my.
They cannot extend it for all times to come. They have extended it twice. Then
My ill health. I will mention.
ill health does not make that, ill health does not affect your money. Whatever, if you have got that amount of money, it will remain there. Your ill health is a different issue unless you have used it. Huh?
Trying to scale some other properties also. Because of that, there is an official process. I am saying only that for the authority that in 31/12/2024 also, I am putting that much of time also. has not been accepted by authority. Now, proposed document I have,
Right, heard Mr. R. Fukan, learned counsel for the petitioner, who submits that the petitioner had taken part in the auction for sale of mortgage land, mortgage building, land and building, land and building. On, when was the auction held?
eighteen, 12,
Huh?
12,020.
18th of 2023. Gustav. The petitioner was the successful bidder for the said land and building at his rate of rupees
48, 4 lakh. 2,000.
huh?
4 lakh.
64,000,000, huh? 02,000. Gustav. Thereafter, the petitioner made part payment of rupees 16,00,500 on 18/12/2023. Gustav. And the petitioner was to pay the balance amount of rupees 48,01,500 on or before 31 31/12/24 is not even over. What are you saying?
Not before watching, 1,4,024.
That's what 1/4/24. Gustav. Not 2/1/24.
Second time extension equal 1,4,024.
Mr. Counsel, let's go one by one. You cannot climb to the 10th floor without crossing the second and third floor. On or before 2/1/2024. Gustav. However, on the request of the petitioner to grant an extension of 45 days for deposit of the balance amount, the same was allowed and the same was allowed and intimated to him by letter dated 29/12/2023. However, the petitioner again made a request by letter dated 5/2/2023, 2024 for further extension of 45 days till 1/4/2024 for paying the remaining balance amount. So, when the petitioner failed to pay the balance amount on 1/4/2024, the respondent number one, is it? The respondent number one issued cancellation of the e-auction held on 18/12/2023 and informed the petitioner that his part deposit amounting to rupees 16,00,500 had been forfeited. The said communication had been made by letter dated 8/5/2024. Next paragraph. The petitioner has approached this court 5 months later and has prayed for setting aside the impugned communication dated 8/5/2024. And to issue a direction to the respondent authorities to allow extension for payment of the remaining amount without mentioning any time limit. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondents by registered post daily within 3 days. Yes. This is the matter out of court. Too late, Mr. Council, you have come out of 5 months. What has happened? We don't know. If a fresh option is taken, then maybe we'll allow you to take back the money. I don't know. You're not paying. This is 1 month, 1 year ago. You're not paying. This is, huh? You want to dispose of the writ petition? Huh? Or that's what you want? I don't know. Let us let you take. We don't know what has happened. Naturally, there's no point. You're not paying. You have made representations twice. It doesn't mean it doesn't mean that every time you send a representation, it has to be considered. There's no question. There's not required. What? No. We'll hear them. The prayer for interim order is not being considered by this court as more than 5 months have passed since the date of the impugned communication. You just say they're not considered, this is not being allowed. Yes, item 20, yes. When was the contract completed? Huh? Page 12.
Lordship 30, page 30.
This is what, with regard to Jashakti? No.
Lordship, we need to obtain instruction regarding this.
No. This is
FMP, yes.
contract work order of 2016. When did you complete the work, madam? 2017. Madam, my question, please understand my question. I did not ask you, whether you studied in America or you somewhere else. I asked you, when did you complete the contract work? You must be knowing, you are the person who has done the contract work. You are asking for money, saying that you have completed the contract work. You should be knowing this fact. It's like asking you, when did you finish your class 10? Which year? You say, I don't know. If you don't know, who will know? The petitioner's counsel shall inform this court as to when the contract work was completed by the petition. This is the matter after a week. Huh? Same, item 25.
Oblige.
27.
Supplementary motion 41.
As per lordship's direction, we have to say instruction.
Have you got a copy for him? No,
One copy is here.
only one copy.
I provide you.
Basically, what they are saying is that 12 out of the 14 infrastructures are completely constructed by ATDC. Whereas the remaining two, parking and boundary wall, have been developed by the Tapatari development block from the NEGA and other development fund over the years. Therefore, ATDC cannot claim sole ownership over the parking and boundary wall.
Property belongs to Boundary Fund. Now, the IGC development of it, of which the chairman was the civil SDO. They were running the.
No, let us see the NIT. Where is the NIT?
Even my lord may kindly peruse paragraph 2 onwards, paragraph 2 onwards. We start from entry and exit of Koyakuchi Park. Main issue is Lordship, after 7 p.m. Lordship.
No, let us see the NIT.
Lordship.
What, you see, if whether all 14 infrastructures had been given, were offered to the tenderers. Copy the agreement. Let's see the agreement.
It's not a base return, it's a tree.
Where does it say 14 infrastructures?
Article 3.1, that will increase 40 well. Where they have stated that.
3.1 is at page 39.
Yes, page 39. They have stated that. The little 14 structures, that's been stated in Annex Schedule A. Schedule A is that page 55. That's part of the agreement.
Page 55.
Yes.
Yes.
Schedule number 6 is the parking lot. And 14 is the boundary of UK.
Yes.
Therefore, if you are kindly turn to page the Annex 4, that page 58 now. That was formal taking over of the. property itself. They mention all the 14. But when he went to take possession of the properties, then this properties are not illegal. But the government is speaking that things are what purpose the civil activity he has to hold back this two properties.
Correct.
My lord, may I kindly place our instruction lordship. Instruction what says that regarding lordship, use of lordship, there two part lordship, in the time, proper timing our lordship.
No, no, that is a different thing. Proper timing is a different thing.
Lordship.
Proper timing you can enforce.
And
But the issue is
lordship,
when you have entered into an agreement,
lordship. Agreement was entered by the ATDC, lordship, not, it is not involved by the Koyakushi Development, Park Development Committee, lordship. There is a two committee. Inside the park lordship, one is lordship, the
and
maintained
the
by the
development committee is, what is it, a
Yeah.
government?
lordship, development
It's
committee.
a government.
Development committee is under the government. law.
Development,
But that-
development corporation, this is a, just a
ATDC.
minute.
ATDC,
The Assam Tourism Development Corporation is one.
lordship, lordship.
That's the corporation.
It's
And
a
what
co-
committee? Committee is made up of what?
Committee, Koyakushi lordship, Eco Park Development Committee. lordship.
Made up of whom? Constituting of whom?
Constituting by the government official lordship, it is a chaired by the lordship, SDO civil lordship,
NGO civil.
SDO civil lordship, SDO civil lordship.
Prior to the.
And lordship.
Is the
rega-
NGO civil a party here?
Yes, no.
And regarding lordship, and regarding lordship, the use of that part, we have no objection. Regarding SOP also, what lordship says, last occasion directed us to.
No, no, Mr. Council,
Lordship.
please, look, no point of, see, the issue is this. There is an agreement made between the ATDCL and this person.
And government has appointed APC as the nodal agency.
Where is that appointment order? Government is appointed the Assam Tourism Development Corporation.
Because they have copy the tender. APC.
Where is the tender?
Tender copy of the NIP.
You have to produce.
Is the, just a minute, is the SDO civil? Has he got any role to play in this Tourism Development Corporation?
Prior to this, they were running the, managing the eco park under the surveillance of the SDO civil. They formed a committee, that committee was running the,
Where is the formation of that committee? What committee did you say the name was?
sites.
Koyakuji Eco Park
Development
Development Committee. lordship.
That was formed by the government. Subsequently, government took a policy decision to run all the tourism spots, participants of the private property.
They have.
Oya Kujia Eco Park, no.
Yes,
Where is the committee name?
Koyakujia Eco Park Development Committee. Below.
Where do you get that development committee?
We made it a part of it.
Okay.
8 is the SDO is chairman of that committee. Below.
TBC is lordship constructing a lordship, the tourism hut or lordship, they have constructed the cottage lordship inside the park lordship, and that cottage is lordship under the jury, under the authority of the ATDC lordship. And the whole park is maintained by the lordship, the development committee lordship. Inside the park lordship, there is a cottage lordship, 12 cottages there lordship. That cottage was maintained by the ATDC. Assam Tourism Development, even they have constructed that cottage also lordship. And regarding that park lordship, surrounded by the lordship, it's a water bodies lordship. And
No, I'm not on that.
lordship.
I want to know what role who is looking after the Eco Park? Who is the
Eco Park
overall
is-
authority?
Eco Park is since 2006 lordship. It was lordship looking by the lordship Koyakushi Eco Park Development Committee. And today also they are, every management is there under. But the lordship cottage inside the Eco Park, that was run by the lordship, the ATDC lordship. The main issue is that lordship, we are open it up to 5 PM. But after discussion with the petitioners lordship, it was extended to the 7 PM. The issue is that after 7 PM, how it should be operated. That is that
So the issue is this,
lordship,
the NIT issued by the Tourism Corporation
lordship.
is beyond their jurisdiction.
Beyond their jurisdiction,
It
only
appears.
they have
I don't know, that is your case.
lordship, lordship,
That is your case.
lordship.
Now you are appearing for whom?
I am appearing for the lordship, respondent number, we are not appearing for the lordship, I am for 1, 2 and 3 lordship,
1, 2 and 3.
Three
And 8.
and 8 lordship.
1, 2, 3, and 8.
Six,
So,
7 and 8.
we will have let the commissioner secretary, tourism department submit a affidavit
Lordship,
clarifying this issue.
Lordship.
Electronic case 36.
Even Lordship, regarding mechanism part, my Lordship last occasion directed the what is the meaning of the mechanism, Lordship, and when what purpose the word mechanism was used, Lordship. So Lordship, my Lord may kindly peruse our inspection paragraph 5, Lordship. Paragraph
Yes.
5, Lordship. And regarding that part also, we have called to the petitioner, Lordship, but he is not cooperate with us, Lordship. In 2 times meeting was held, Lordship.
Okay, anyway, the problem is what has happened is the agreement
Lordship.
has been made,
Between the Lordship,
including, yes, including all these issues.
Lordship,
So we have to want to see
Lordship.
whether the ATDC had the right or the.
Overall control of.
Yes,
Lordship,
so now this is an issue that should be decided by the secretary,
Lordship,
whether this court should decide this issue. No, Mr. Counsel, please understand, not turn to this or turn to that. The issue is this, from what I can gather. According to the NIT which you have not annexed here, 14 infrastructures were put to the tenderers. And 12 of them have been given to you.
Yes.
2 left. Now these 2, the parking and the boundary wall, according to them, is that this is not the purview of the ATD, the corporation. It is the purview of the committee.
Yes.
Now let the committee, whether the committee is to run the entire eco park or a part of it, or you are to run the entire park or part of it, that will best be decided by the government. So why should this court decide?
Decided that.
Where is the government?
no,
The problem is, where is the tender?
It's.
You please,
it's by the corporation, Lordship.
that's what,
It's by the corporation.
no,
Lordship,
that is all right.
Lordship.
Okay, then let the secretary, government of Assam, submit an affidavit
Yes.
with regard to your, no, you please give the NIT first.
Yes.
You see, you half-baked reputation you're giving. Right. Heard Mr. R. Shekhar, learned counsel for the petitioner. And Mr. K. Roy appearing for respond number
1, 2, 3, 6, 7, and 8, Lordship.
1, 2, 3, 6, 7, 8. Mr. M. Chetty appears for?
Lordship.
No, that's one, okay. The petitioner's case is that pursuant to a NIT dated Huh? Pursuant to an NIT floated by the Assam Tourism Development Corporation Limited bracket ATDCL for management and development development and operation of the Koya Kujia Eco Park for a period of 5 years, The petitioner was declared the successful tenderer. Accordingly, an agreement was executed on 29/5/23 between the ATDCL and the petitioner for operation of the Eco Park. However, only 12 out of the 14 infrastructures that were to be handed over to the petitioner in terms of the agreement have been handed over to the petitioner. The parking infrastructure and the boundary wall of the Eco Park have not been handed over to the petition. This court had instructed instructed the counsel for the respondents to obtain instructions in the matter and as per the instructions received by Mr. K. Gogoi, comma, there is a jurisdictional issue in respect of the Eco Park. Since the ATDCL structures inside the park were leased out to the petitioner. The stand of the submission made by Mr. K. Gogoi is that 12 out of the 14 infrastructures were completely constructed by the ATDC, comma, while the remaining two infrastructures, comma, that is parking and boundary wall, have been developed by the Tapatari development block. Full stop. Therefore, comma, ATDCL cannot claim sole ownership over the parking and boundary wall. Full stop. Next para. Mr. King further submits that the Eco Park has been run by which committee?
Lordship, it was by the Lordship Koyakuchi Eco Park Development Committee.
Koyakuchi
Eco Park Development Committee.
Eco Park Development Committee
Since
under the
2006.
chairmanship of the SDO Civil
Lordship.
since the year 2006. And as such, the ATDCL has got no role to play in trying to lease out the parking and the boundary wall of the Eco Park. Full stop. Next para. On the other hand, the stand of the petitioner is that the government has entrusted the leasing out of the entire Eco Park to the ATDCL, comma, for which an NIT was issued. The petitioner, having been declared the successful tenderer, and in terms of the agreement dated 29/5/2023, executed between the ATDCL and the petitioner is to be given possession of all the 14 infrastructures, 14 infrastructures, comma, including the parking and the boundary wall. Full stop. Next para. The petitioner shall produce the concerned NIT on the next day. Full stop. Further, this court is of the secretary to the government of Assam, Commissioner Secretary to the government of Assam State Tourism Department should submit an affidavit and clarify as to whether the parking and the boundary wall, which is mentioned in the agreement dated 29/5/23, signed, executed between the ATDCL and the petitioner, can be leased out by the ATDCL to the petitioner.
Lordship, Lordship.
This will take care of everything. The affidavit should be submitted within 2 weeks.
Lordship.
List the matter on, give a date.
Lordship, will do.
I think that will take care of
Lordship,
everything.
Lordship.
If he says either way, you know what to do. One, you can file a suit for damages or something.
Congratulations.
This, we have challenged the district councils that in NIC. So what has happened for these two Anganwadi centers, such these kids where all 200 crores. Well, we have three grounds of attack. The first is the lordship will turn page 85. First of all, we were given a very short notice of spending. And on our representation, this was extended to Monday next week. The lordship will find that the comparative statement.
Monday next week is what date?
28.
So that ground is gone.
Yes, that's. But in stringent conditions are there, lordship will find that the comparative statement of average annual turnover requirement, where Second column will also find the bid criteria for manufacturers. of
Which page?
Page 85 and extra text.
Yes,
Bid criteria for comparative, for manufacturers for average annual turnover before issue of bid for a tender. Well, these were the rates. 20 crores for jumbo color pencil. And total was 1,299 crores. Logical find, the fourth column, the third column, the bid criteria is for manufacturers. for
yes.
annual turnovers after issue of the.
What do you mean by OEM? What is OEM?
term, the problem is
The problem is that you should have also asked for it. Without knowing the terms we are trying to enter into the selection process.
well, this point for the. Well, what has happened? Logical find that they have increased the amounts in all the columns of the 18 for 16 days paints. But down below water bottles, they kept it 150, same.
So?
And look, the point is that they brought in an additional qualification criteria. Page 66, logic will come to page 66.
No, just a minute. Page 85. So all these turnovers have been decreased, and except for
And another.
so that have remained the same.
Yes.
So what
Now,
is wrong?
what's happened? Therein, they add, in the 18, that is the water bottle, the logic will come to page 66. Qualification criteria, there is no qualification criteria for the 17 items, but for 18, down below at serial 7. Manufacturers must have a past experience for supply of minimum quantity of 3,20,000 numbers of PP water bottles in a single work order, any central government during the last 3 years. The copy of the orders and the should be furnished. Well, this is the stringent condition on which we don't come in. And the most important thing is that they bring in a criteria which goes against the central government's guideline. That is very important. Lordship will turn to page 86. Followed in order to reduce cartel and all, the central government has been informing the governments that you remove certain criteria when you go for tenders. Here, what has happened? Page 86. Well, this is my.
I know you're talking about the sample.
Yes, ma'am. So now, the fact that they have put in a sample and we put in a representation, and in the circular, the lordship will come to page 87, at serial 5, there is a specific order, if I may read, page 87, 5. Further, should any seller have any objection demands against these additional clauses or otherwise, on any aspect of the bid, they can represent against the same by using the representation window provided in the bid. Details filled in a seller's dashboard after logging in any seller within 4 days of the bid publication on GM. The buyer is duty bound to reply to all such representation and would not be allowed to open bids if he or she fails to reply to such representation. Well, they don't give me a reply. One part I get it.
No. You see, so this is the pre-clarification clause. Pre-bid clarification clause. Now, when did you submit your representation?
We submitted it 20 to 10 at page 91.
22/10,
Yes.
24. Now you see, this has to be done within 4 days of the bid publication. Now, when was page 66 issued?
That was with the NIT 9th of.
That was with regard to the
Nine of
3,20,000 bottles.
Yes,
That was within when? When was this issued?
9th of October.
9th of October.
Yes.
And your
And the
representation,
sample thing was also brought.
just a minute, and your representation is of 22.
But on 19, they wanted the bid should be open.
No, 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 leaving that aside, Mr. Khan, let one thing at a time. This requirement of the manufacturer having past experience for supplying 3.2 lakh bottles of bottles. Now, this was issued on 9/10/2024, correct?
19. Or 9.
9/10. Now, in terms of page 87, you are supposed to submit your representation within 4 days of the bid publication in GEM. So you have missed the bus for this 3.2 lakhs. The only thing now that remains to be considered is with regard to the sample. Because you cannot now, since you have missed the bus, you have missed the bus.
Your lordship takes such a strict.
Yes, because I have passed orders. Yes, you see, I'm not dealing with contract matters once in a blue moon. Every day it's coming. And I think I have dismissed 2-3 cases this already in this, on this aspect. Pre-bid clarification clause is there in a number of contract NITs. So when you miss that bus, you cannot say that, no, you have missed it. Now, that is one. Now, the only thing that remains subject to correction is with regard to the sample. So now, so you are relying basically on this page 86.
And the fact that like in page 86.4.5, Roman 5, seeking samples with the bid or approval of the samples during the bid evaluation process. That the bar is there, you bring it in and call upon us to give the sample. So that is the issue. I call upon.
That is, but, 28/10 is the last date.
It's okay. It's okay.
Gotcha. As regard the.
No, what we can do is, you see, for this,
Okay.
for those who have, we can say that they can submit their bids without the sample. If they don't have sample, whoever has samples, they may submit. Who doesn't have samples, they may submit, may not submit.
Gotcha.
However, the issue whether the samples will have any determining factor at the time of the technical bid evaluation stage, that will be subject to the outcome of the writ petition.
The subject is logic.
So that nothing is stopped. But with regard to your other grounds, they go.
Gotcha.
That is my finding.
In fact, page 8.
No, there's no question of keeping. I'll clarify that. You can go in appeal if you want.
In fact, the representation at page 91, just if lordship is,
Huh?
if we are confined to that only, to the sample question, that I have no other submission.
Naturally,
Otherwise,
because they have got to follow when they are relying upon the NIT, they have got to follow the terms of the NIT.
Yes, my lord, absolutely, they have to follow, and the representation,
Unless they challenge the terms of the NIT,
yes,
or unless, you see, one thing is that they are relying upon, you see, sample, the issue of sample, the question raised by the petitioner is on the basis of this letter of the
First of March.
yes, 1st of March
the-
2024.
of the central government.
So,
Got
because of this letter, this issue will be taken up.
My lord.
But the issue of pre-bid clarification, this is also in the same letter. So they cannot say, I accept part of the letter and I do not accept
No,
part of the letter.
cannot.
If they want to do that, that's a different
They
issue.
cannot.
And in fact, one more submission at page 7, page 87, para 7, the central government had raised this issue and have clarified it that their norms have to be complied by the state because there is a understanding between the state and the central.
If you don't have a
And
sample,
states
don't
were
submit.
violating it. That's the content of the letter. Will lordship allow me to read that?
Yes, okay.
Yes. Further, when representations are received regarding bid conditions not conforming to the GEM, it's bound to scrap such these when clauses mentioned in the bids are restrictive in nature or in violation of the procurement rules of the government of India. It has been also noted that when a response is sought from the buyer for such bids, some of the buyers justify these wrongly created bids, citing the state's procurement policies and rules. It's pertinent to mention that the state government has also signed an MOU with GM when the state government has committed to the procurement rules, procedures of the state government shall be amended in such a way to the maximum extent possible, they may be in sync with the procurement rules of the government of India, make changes to the procurement rules of the state government in line with the rules 149 of the government of India. Therefore, in order to ensure fair and transparent procurement, the state government may remove any enabling provision in the procurement policy that may lead to inclusion of any of the conditions mentioned under para 4 above. All buyer organization also be adequately sensitized accordingly. Looking forward for a continued support. So this anomaly is there, and this letter
No, no,
specifically says that this has to be looked at. And in fact, there I miss out because it's a state law. It's a the competition has to be wide. I'm shunted out on this, so I have a right to take that.
Well, the page 85, in fact, page 85, annexure 10, Lordship has seen. If they said that we have,
No, they cannot challenge this.
that they cannot.
No, I'm not saying.
And Lord, they pay.
I mean, they can challenge, but whether the court will accept, that's a different.
Not at this. not
As
at
cons
this
is
stage,
there
not
and
at this stage.
out here, you see, this is the thing is that they have not asked for any pre-bid clarification
No.
on this annual turnover. At the time it was published in the portal.
Portal.
They have not
We-
asked. And
we-
now, as per the change in the criteria, it has become less.
So
So
it has
that
become less.
doesn't cause any prejudice.
Correct.
So that,
Correct.
I'm not on that.
So their case projected is that it has been enhanced, but this.
No, it is less. It is
It
less.
is less.
Everywhere it is less.
That is what the case is.
It is less.
Leave on that. My friend has an addition.
One clarification. I was respectful submission. After the bid was, after the bid was, advertised in the web portal, we have raised one, representation. That representation has not been annexed.
Sorry, Mr. Council, we cannot go to some things you have not included in your petition. Sorry.
In my book.
No, that now you can, now even if you, now you can say that we did not, though we had submitted 102 representations, they did not answer. I do not know. You are duty bound to put all things before this court. You cannot hide facts. You cannot play around with facts. And I have to go in terms, I have got to consider only the documents that are here in front of me.
Granted, liberty will bring it by finding an.
No, that you want to do, that's a different thing, but as on date, I don't find any case. Except with regard to samples, that's all.
Mara.
You cannot make such submissions. And that also you're coming at the fag end,
Today is the last day in fact.
last day.
The last.
Only thing is that, one thing, you cannot insist upon samples.
To that extent, I will take the instruction,
Yes.
what they have done, because some further clarification after March 2024, they may have, I don't know, I have to open instruction.
The only problem is the opening is the last date is 28.
28.
28 is when?
28 is the Monday.
Monday.
Tomorrow and day after tomorrow are the holidays. To that extent, Malad, I'll obtain instruction and definitely if the.
So what we are going to, so we'll allow all the tenders
whoever
to
is
be accepted?
participated- Yes,
provided, no, even if they do not have samples.
Lordship.
And the question of whether samples will be a determining factor, can be a determining factor, will be decided by them.
That Lordship will decide. That Lordship will decide subject to what instruction I receive, but I will place it.
And, right. Where is your representation, earlier representation here?
Page 90,
92.
91.
But I have one submission to this representation, Lord. For this representation, kindly see dated 21/10/2024. And the affidavit in the representation has been shown on 14/10, Lord. Page 23.
Page 23.
23. The copy which has been given to me. Date is given there. Lord. In my copy, it is 14/10/2024.
Huh? In mine, 2410,
My copy is 14/10.
2014. This writ petition has been filed today. No, today is what? No, today is 25.
Today is 25. My copy, yes, it is 14.
Okay, you have said that on your representation. Where is the representation that you should be given some more time?
One more time, we have made our representation. Well, this is the pursuant, this representation was pursuant to the original petition. Because our entire case came in, everyone got released, that part remained, and that was the stringent petition.
No, because you said that on the basis of your representation.
Agenda was issued on 21, we put in our.
No, then you said that the time limit for submission of the tender was enhanced, was enlarged. What was the earlier date for last date? Hmm,
And the cutoff date was 19th of October.
19th of October.
And for the three changes, we had already submitted one certificate of voter. Basing upon which they fixed the date till 28th.
Okay, in the portal you submitted when? Which date?
On 14th.
On 14th you submitted.
And this 19th. Then this 14th of April, issued an executive leave and another representation on 21. Because
Okay.
again, the second.
So on 14th then you submitted a representation in the portal.
That the short span of time, we could not submit the test report. That was one of the conditions.
Okay, so 14th then what is the representation submitted in the portal?
What was the test report we could not submit because there was holiday and we could not obtain it from the NEP. The other ground was that for the stringent condition portal that 7 experience. In one shot, you have to clarify it like 20,000.
So they gave you more time.
They extended the time to 20.
Is it because of your letter or somebody else?
There were numbers of it in fact.
Okay. Okay.
The second time, and the Korean version, but he thought that uniformity was not in respect of the water bottle, whereas all other items in for 85 lots.
No, but then this page 66
Got
regarding the bottles was part of the original tender notice.
that was
Then
61.
what is that? Right.
Should we read both of the issues?
Maybe. Correct. Now all of you all have argued. No one can say that none. You all are not given a chance. Right. Heard Mr. Whose name do I put in? DK Das, learned counsel for the petitioner. Who submits that the bid document dated 9/10/24 and the tender inviting bid bracket NIB dated 8/10/24 and the corrigendum dated 18/10/24 issued by the respondent number 2 should be set aside. The petitioner's case is that the NIB, the tender, the NIB did, the tender, just a minute, what is it? NIBs of 8/10? That is in your prayer, how can it be 8/10? Bid document is of 9/10, how can the NIB be 8/10?
Was supported with it. But the page 46.
Okay, right. Submits, the petitioner's counsel submits that as per the NIB. Comma. NIB dated 8/10/2024, which was uploaded with the tender documents on 9/10/2024. The the qualification criteria for manufacturers at item number 18 stated that the manufacturer must have past experience for supply of minimum quantity of 3,20,000 numbers of PP water bottle in a single work order to any central/state/government department during the last 3 financial years. The petitioner's counsel submits that the said condition for having the past experience for supply of a minimum quantity of 3.2 lakh bottles, PP water bottles, was what? In a single order was a stringent condition and could not have been made a part of the past experience of a bidder. Full stop. Next para. The petitioner's counsel submits that the entire supply order having an estimated amount of rupees 225 crores, comma, the time limit provided in the tender documents for supply of for submission of tender on or before 19/10/2024 was too short a time for the tenderers to submit their tender document. First off, however, on the basis of the representation made by the petitioner on 14/10/24, is it? But is that, where is that, have you stated in your writ petition? However, on the basis of, then how on the basis of the representation made by the petitioner, which is not annexed to the writ petition, comma, as the same was uploaded, comma, the tender condition, the last date for submission of tender was extended till 28/10/2024. Next paragraph. The petitioner's counsel further submits that, where is that sample requirement page? Submits that in terms of item
21, 861, 21.
submits that in terms of the qualification criteria for bidders as provided in the NIB at serial number 21, required the bidder to submit one set of sample of growing essential kit for conformity of the specification as prescribed in the product specification given in the bid documents. First up, page 61, huh? It is serial number 21, okay? He submits that in terms of the CVC, is it CVC? No. He submits that in terms of the letter, in terms of the DO number 22/CEO-GEM/2024 issued by the Chief Executive Officer, Government of India, Ministry of Commerce and Industry, Government e-Marketplace, page 86. Huh? Any clause incorporated by a buyer in a tender regarding seeking of samples with the bid or approval of samples during the bid evaluation process should be treated as null and void. Accordingly submits that the qualification criteria for bidders at serial number 21 of the NIB should accordingly be treated as null and void. And null and void, full stop. Next para. The Petitions Council further submits that in terms of para 5 of the same letter, of the same DO number 22/CO-GM/2024, dated 1/3/2024, any seller having any objection/grievance against the addition, against any clauses of a bid can represent against the same by using the representation window provided in the bid details field in the seller dashboard after logging in as a seller within 4 days of bid publication on GM. The buyer would thereafter be duty bound to reply to all such representations and would not be allowed to open bids if it failed to reply to such representations. So did you submit it in the window, representation window? I uploaded it. Did you upload it? You did not. No. That is you're making up. When was the representation submitted? 21, correct. And this sample was there from 9th. From the beginning. That's what I'm saying. So you see, after logging in a seller within 4 days of bid publication. So bid publication was 9. Your representation was of 21st.
Of the total, submitted on 30. First PM submitted on 30. When they extend
Where have you said that?
that is
No. Sorry. Sorry.
of the
No, sorry. Anyway, right. I'm the whatever I said. The petitioner's counsel further submits that the petitioner had submitted a representation against the requirement of a bidder having to submit a sample in terms of serial 21. Of the qualification criteria for bidders on 21/10/2024. However, the same has not been replied to by the respondents. Full stop. Full stop. Next. Yes, what is your submission, Mr. Nath?
Well, my submission is not. Firstly, Lordship, even if they have requested and it has already been modified, the turnover has already been taken down. Page 85, Lordship has seen. And what in the representation they have represented, page 93, kindly see. They have said I'm just indicating 2, 3 paragraphs from bottom. Kindly see last fourth paragraph. That this is a kit which contains 18 items of so and so change of in the manufacturer's turnover requirement figure should be affected in unit.
Anyway, right,
That
okay.
is their grievance.
Ah.
And the last sentence, what they said, kindly see, the malicious intent of the director is distinctly reflected in the case of manufacturer so and so. And this representation they are sending to the director himself, that your malicious intention is there, that you modify all the terms and conditions.
Anyway,
So
anyway.
basically that is their grievance.
Mhm.
So this representation,
With regard to the sample, what have you got to say?
sample thing, or I need to take some.
Take
instruction.
instruction,
Logic has-
okay,
Logic
okay,
has-
right.
Logic has indicated that
Yeah.
process will go ahead and subject to.
Correct, that'll
that
go ahead.
Logic.
I just want something to add out here
Malad,
because you have to got to
Malad,
say something also, no?
But at the last hours, Malad, they have come up with the demands,
Okay,
which is already addressed, which is in fact redressed, Malad.
okay.
Because they said that restrictive clauses by putting the higher turnover has been given from page 79 onwards. Logic has seen the.
It is all lower, in fact.
That is,
Yes,
that
that's
is,
what.
that has already been.
In fact, when I read the synopsis, it was something, it was
It is
higher,
something else.
it was higher. When I read the main, it was again something else.
Yes.
Because they said some were higher, some were lower. But when you showed me the thing,
Well,
yalla not clear, or either you are
Horizontal-
trying to,
Horizontal.
I don't know, you are confusing the issue, but it has been clear by the document.
Kindly see page 83 correction now. Well, earlier lot of certificates are required. Now it has been reduced. to-
Anyway, right.
No,
Heard
see,
Mr. Deenath, learned counsel for
So
the
there is-
petitioner.
My submission.
Heard
is that
Mr.
there is no
Deenath.
restrictive clause,
Heard Mr. Deenath, learned counsel for the respondents,
1 and 2.
1 and 2, who submits that there is no restrictive clause in the bid documents, especially when the time for submission of documents has been extended from 19/10/2024 to 28/10/2024 by the respondents. Full stop. Further, in terms of where is that document, the turnover?
Turnover document corrigendum, it starts
Page
at,
80.
it starts at page 77. What?
No, at page 85.
85.
Further,
In
in
chart.
terms of the comparative statement of average annual turnover requirement from bidders in the bid and after issue of the bid corrigendum, which is provided in annexure 10 of the writ petition, comma, the same shows that the average annual turnover after issue of the bid corrigendum is less than the requirement in the bid document, in the NIB,
Original.
full stop. Except for the turnover for water bottles, which is the same.
And pencil box also, 1 or 2 items.
For water bottle and water bottles, comma, scissors and pencil box, huh? Next. He submits that he would, however, require instructions with regard to the submission made by the petitioner's counsel regarding the requirement of bidders to submit samples along with their bid documents. So we issue notice or what?
In terms of that, government,
Huh?
jam letter, in terms of the jam letter.
Correct.
Guideline that.
Issue notice first.
Logic.
Issue notice returnable in 1 week. 2 weeks,
Logic will give 2 weeks.
2 weeks.
Okay.
Mr. Deenath accepts notice on behalf of respondents number 1 and 2. Who else?
1 and 2.
Petitioner will take steps for service of notice upon the respondent number 3 by a registered post with AD within the course of the day. Full stop. Next para. The challenge made to the tender and the corrigendum by the petitioner is basically on two grounds. In view of the fact that the in view of the fact that the grievance of the petitioner regarding the short period of time given to the tenderers to submit their bid has been extended by the state respondents from 19/10/2024 to 28/10/2024. First up. The only two issues that have now been brought out for consideration is with regard to whether there was any restrictive clause slash condition in changing the required turnover of the bidders. Which required the bidders to, what have I said to it? Is with regard to whether the change in the average annual turnover requirement from bidders before and after the issue of the bid corrigendum was restrictive and arbitrary. Was restrictive, arbitrary and unreasonable. Secondly, whether the submission of a sample, secondly, the requirement of submission of a sample of the growing essential kit by the bidder in terms of serial number 21 of the qualification criteria of bidders was sustainable, keeping in view the DO number 22/CEO-GM/2024 dated 1/3/2024. First off. The above DO letter dated 1/3/2024 states that the seeking of samples with the bid or approval of samples during the bid evaluation process incorporated by the buyer in the tender notice shall be treated as null and void and would not be considered to be a part of the bid. First up. The above clause in the DO letter dated 1/3/2024 prima facie appears to show that a bid submitted by a bidder without the samples cannot be rejected only on the ground that the samples have not been submitted along with the bid documents. First off. Next paragraph. Para 5 of the DO letter dated 1/3/2024 states as follows. I take it, page 87. The said clause provides that a representation can be made in the representation window against any clause in respect of a bid within 4 days of the bid publication on GM. So, in the present case, the petitioner has apparently made a representation only on 21/10/2024, which is not within 4 days of publication of the conditions which has been put to challenge. Full stop. However, in view of the fact that seeking samples with the bid or approval of samples during the bid evaluation process appears not to be proper in terms of the DO letter. This court is of the view that the petitioner and others who have submitted their bids without samples may also have their tender documents, bid documents considered by the authorities at the technical bid evaluation stage. Full stop. Next para. In the case of AFCON so and so, so and so, so and so, the Supreme Court has held as follows. Full stop. Next matter. List the matter on 11, by which date the respondent shall submit their affidavit and produce records if necessary. Not necessary. No, shall submit their affidavit.
Clarifying the sample point.
No, I want to know what representations they have put in there in the they have uploaded.
If any.
And records if required, Full stop. Yes, it is made clear that the financial the financial bid should not be opened till the time. And it is also made clear that it is also made clear that the issue whether the bids of those bidders who have submitted the same without submission of samples can be awarded can be considered further for in terms of the NIB would be subject to the outcome of the writ petition. So that issue we're still leaving open.
Not. We will respond to that one.
Is there any pre-bid clarification clause in the NIB?
There has to be.
Huh?
There has to be.
I think that, just check it out. No, so where is that? The response, the counsels for the party shall show this court the pre-bid clarification clause provided in the bid documents by on the next day. What affidavit? No, we'll see. We'll see.
Gotcha.
We'll go only by the record now. We cannot fetch documents.
We'll submit.
No, we do not know now what documents will come out. You are supposed to produce everything now, not, no.
We get a right of
We do not know. We'll see when that, we'll cross that bridge. We'll cross that bridge when the, when we reach.
time being 27.
Quickly. Petitioner. Till after with IOC. Agreement was for a period of 15 years, executed in 2012. In January 2023, they introduced a rewards program where points are to be allotted in lieu of the fuel that is consumed. And this was for a period of 3 years. What happened was this, madam. 3 months, sorry. And this was not even notified. They informed us through WhatsApp and emails and all. And suddenly we get these letters at page 55. 3 identical letters. 55, 56, and 57. What they say is this. They call it a fact-finding letter. And this is how it reads. It has been observed that during the month of January 23, the extra rewards transactions at your retail outlet was more than the actual fuel sales recorded during the period. The details of the transactions as per the findings are given below. And they record that the actual sales are not up to the, not equal to what has been shown. This is in violation of the corporation policy and guideline. In view of the above, you are requested to submit your explanation within 7 days from the date of receipt of this letter on above violation. If no reply is received or reply received is wrong, unsatisfactory, then action as deemed fit as per corporation guidelines will be initiated. Now, identical letters are 56 for the next month and 57. Now, in response to this, we write this reply on page 58.
Yes,
With reference to your fact-finding letter number so and so, it is to inform you that the abnormality happened due to misunderstanding, lack of proper monitoring and guidance. We were instructed to enroll more and more customers in the extra rewards program and to give them maximum benefit through redemption. As the whole process was offline, our CA engaged for redemption purpose, put the enrolled customer mobile number in XP sale so that the customer gets the maximum benefit. It would have not been happened if the whole process was online system. However, the customers got the maximum benefit in improving the sales of MS, HSD, and FP at that time. If anything, please don't, I request somebody to put. So he basically wrote what he precisely felt. And the reaction to this was page 50. It has been observed that during the month of January 23 to March 23, the extra rewards transactions at your retail outlet was more than the actual fuel sales recorded during the period. This is in violation of corporation policy and guidelines. What policy, what guidelines, we don't know. Fact-finding letter in this regard was issued to the dealership on 19/4/24, and your reply was received by us. Based on the above, competent authority has approved a penalty of rupees 52,87,367, and the same has been deducted from your account as per corporation guidelines. What happens is, we are supposed to make advance payment for the fuel that we procure. And the moment we deposit that, they deducted it against the penalty, and after that, they informed us. Now, we accepted it in good faith, saying that we have been doing business with you for such a long time, we have not had any problems ever in the past. In good faith, we said, all right, this 52 lakhs gone. Now, they maintain their books of accounts, annexure F, page 60. This is how they maintain it. And this is available online in their websites. If your lordship comes to page 60, towards the middle, against Bongaigaon RC office, about in the second column,
just a minute, Bongaigaon, where?
in the extreme left, it
Yes,
says heading is plant. Below
Yes.
that, your lordship will find.
Bongaigaon, yes.
On the right hand side, 2-3 rows below, your lordship will find penalty, extra rewards,
Yes,
irregular. Against that, this exact amount is shown, 52,87,300.
67. All right, fine. Now, what they do is this. When we generate this entire thing, if your lordship will kindly come to page 72. And in page 72, again, Bongaigaon RC office, about 8th row from 8th or 9th row from top, your lordship will find another penalty extra reward. And my lord got it. In the second column.
No, I don't find any extra reward.
Page 72,
Yes,
in the head, under the heading item text,
yes,
about 11th my lord, item your lordship look at. Again, penalty extra. 11th row, under item text. About,
yes,
as my lord,
yes.
penalty extra rewards. And towards the right, debit, your lordship will find another 1 crore. This is absolutely behind our back. We had no idea. And now what has happened is, if we deposit any money for procuring fuel, they will keep on deducting against this. So in the last few days, I am without any supplies of fuel. Because the moment I deposit, they will deduct. And this, they themselves say that a penalty of 52 lakhs has been approved and they already deducted it. And without any raising any, because that was also without following the principles of natural justice. They simply issue a fact-finding letter citing some policies, some guidelines, but in good faith, I accept it. Now, this additional, where did it come? So my respectful prayer at this stage is the lordship will issue notice. Let them not deduct it against this penalty. Till
They have already deducted.
no, this is yet to be deducted. This I came to know only when I had a look at from their website of the from the books of accounts, and I downloaded it, and that is how I came. And immediately I have
No, you tell me, what is this policy anyway, this scheme? What is this scheme?
the scheme is something to do with all petrol pumps nowadays. All the companies come up with this scheme, especially during festive season or otherwise. That if you get more and more customers, you give them award points. And again, those points can be later on redeemed or something like those kinds of schemes. And it was for a period of 3 months. There was apparently some mismatch with the actual sales and the points. Because they did not have any guidelines, they did not have any notified. They simply sent it to us on WhatsApp and sent us an email. And based on that, we started doing it. And all this while, my lord, I have been running it since 2012. Till now, there's no complaint whatsoever. Would it be fair to deduct such huge astronomical amounts like, well, this is my only source of livelihood.
This is for the customers, for the guys with the normal cars,
Yes.
Maruti cars and all.
Yes.
I never heard of it.
But they give in some of the companies come up with these rewards.
What do
It's
they,
like-
what do they give? Cheaper petrol and diesel or something?
No, my lord, they get the point because my lord, the customers will come from other companies to my lord IUC.
How do you know who comes here?
That's why, my lord, they move the my lord customers that get this reward when registered. Then you, for every 100 rupees, you get 40 paisa. So that good. And that against phone numbers, my lord, that is given and that is being paid, and that is how, my lord, in order to mobilize customers.
Basically, well, it is a matter of record that because of this scheme, I could generate, there were a large number of customers, the sales increased. Some mismatch, all right, I accept that. And having accepted it, I agreed to that 52. Where did this 1 crore? And how will a person like a small dealer survive? 1 crore deducted, he will be from the streets. And that too like this, without any notice, nothing.
No, my lord, my submission will be that, my lord, some documents are required to be produced by your lordship. First, the scheme.
Correct.
The scheme is not here, my lord. And there is an agreement with the, my lord, each and every dealer. That is also not there. But then I have got court instructions, my lord. Now, my submission is, my lord, the first reduction of 52 lakhs, my lord, he has agreed, he has apologized. And my lord, he has agreed to that.
Yeah.
Thereafter, my lord, there was an audit. And after that audit, my lord, this has been given. Now, my lord, my submission prayer before your lordship will be that he has already filed a, my lord, representation on, my lord, the reparation, your lordship will find at page 74. What I'll suggest, my lord, perhaps that will also be more beneficial for him. Your lordship will direct the RUC to dispose of the reparation at the earliest, my lord. And thereafter, my lord, he has got any grievance, my lord, then he can still come, my lord.
Okay, in the meantime, you don't deduct this 1 crore. In the meantime, don't deduct the 1 crore.
Till the
Till a
repar-
decision is taken.
My lord, that point is all right, but then, my lord, if
It can
he,
be only for a period of 15 days, my lord. Let them decide it within 15 days, still there. At least I should be allowed to continue my business. I have been without a business for the last so many days.
No, this scheme is still on
No,
or
no,
not?
it was only for 3 months. In January to March 2023.
no, it's continuing, my lord.
Huh?
Once they get registered, my lord, this benefit goes to the customer, my lord, and that was a fraud, my lord. Actually, it appears from the.
Okay. So whoever gets registered,
Yes,
so the benefit of that scheme that for the 3 months period,
yes,
it
That
gets
continues.
extended to those persons who are registered.
that continues.
Continuous.
And if the scheme is there, and that, my lord.
But then how much are you going to keep on deducting? Acha, now that, so this, according to you, if this 1 crore is paid, entire thing is settled.
That is what they told us when they took the
52.
52.
This was after audit, my lord.
Right? When
After audit.
your lordship will kindly peruse their own letter at page 59. What it says is, a penalty amount of rupees 52 lakhs or has been deducted from your account, and this is after approval. Approval means approval from the higher authority. So after 1.5 years, to behind my back without notice, that is out and out not promised.
My lord, since, my lord, all the scheme is not before your lordship, my lord, the agreement is not before your lordship, my lord. Your lordship,
Agreement
my
we have
lord,
next,
Agreement for criminal speed, right?
page 29.
Page 28. So, my lord, I think that will be the best course, my lord, because there are, my lord, disparate questions of facts also here, my lord. I'll not go to that now. What I submit is that, my lord, let the authorities here file the representation. Your lordship will direct to, my lord, the consider it and pass a speaking order on it. That will be my prayer.
Then in the meantime, you don't deduct that 1 crore. And you allow him to run the petrol pump.
My lord, for a week, my lord, your lordship says if it is a week, my lord, then we'll dispose of, my lord. Maybe by Wednesday we'll dispose it
I'm
of. my lord.
already going every day's business. Your lordship can appreciate a petrol pump. Every day I have been incurring a huge loss.
Yes,
Since the day I came to know, I have not,
Because you made some illegal profit.
no,
Yes.
the benefit goes to the customer. The dealer has nothing to gain.
It did not go, my lord. That is-
Actually, the thing is that I do not know. Sometimes maybe I've never heard of these schemes. Otherwise, I would have
In fact, I also.
I would
did
have
not know that-
registered my phone for till.
In fact, my lord, after this case was filed, I asked the, my lord, ISA, then they said that why did you tell me so that I could also get.
Yeah.
When he said you do it now, it is open still.
40 paisa you save every letter.
Yes, my lord. So, my lord, let it be disposed of by Wednesday. We'll dispose of, my lord.
We'll dispose of the repetition, you mean?
My lord.
Huh?
Yeah, therefore, disposing of the, my lord, the representation, your worship will give short time period, I will say, my lord. Then dispose of till that, my lord. Then let that be status quo, my lord.
Correct. Heard Mr. I. Chowdhury, Leonard Senior Counsel for the petition. Assisted by Mr. N. Kalita, who submits that the petitioner has been a retail outlet dealer for sale and supply of petroleum products of the IOCL since the year 2012. In the month of January 2023, a scheme namely, inverted commas, New Year Extra Rewards, XTRA, does not E, Extra Rewards Bonanza, inverted commas closed, was introduced by the IOCL to attract new customers, by providing reward points, which could be redeemed by customers in the respective retail outlets. The petitioner, acting upon the scheme, enrolled number of possible customers under the scheme. Under the scheme. First off. However, the petitioner was issued a was issued 3 fact-finding letters, all dated 19/4/2024, stating that it had been observed during the month of January to March 2023 that the extra rewards transaction at the petitioner's retail outlet was more than the actual sales recorded during the period, which was in violation of the corporation policy and guidelines. Full stop. The petitioner was accordingly asked to submit a reply to the same. Next, the petitioner submitted his reply dated 25/4/2024, stating that the abnormality has occurred due to a misunderstanding and lack of proper monitoring and guidance. Full stop. That's all. Full stop. Thereafter, the the IOCL issued a warning letter dated 5/6/2024 to the petitioner, informing him that the competent authority had approved a penalty amount of rupees 52,87,367.10, which had been deducted from the petitioner's account as per the corporation guideline. The petitioner was also warned to take extreme care while updating the extra rewards points to the customer and to follow the company policies and guidelines. Next paragraph. The petitioner's counsel submits that subsequent to the above facts, the petitioner accepted the deduction of the amount of rupees 52,87,367.10. And the same has also been reflected in the IOCL accounts which were in the public domain. However, the petitioner was surprised to find that another amount of rupees 1,05,99,734.10 was again sought to be deducted from the petitioner's account towards penalty regarding the extra reward scheme. The petitioner's counsel submits that no notice has been issued to the petitioner with regard to the above action proposed to be taken by the respondent. He further submits that when the petitioner has already been inflicted with a penalty at an earlier point of time, which has been approved by the competent authority, the respondents cannot inflict a second penalty on the same ground. That's all. He also submits that the petitioner has not been has not been able to operate his petrol pump due to lack of lack of supply of petroleum products by the IOC. Next para. Mr. M.K. Chowdhury, learner senior counsel for the IOCL, assisted by Mr. P. Bhardwaj, submits that the petitioner has submitted a representation dated 17/10/2024 to the respondent numbers to the respondent number 2 and 3. With a request to not act upon the proposal to deduct the proposed penalty amount of rupees 1,05,99,734.16. It is 16, not 10, huh? 0.16. And to supply oil to the petitioner on regular basis. Full stop. As the said representation has not been decided by the IOCL, the direction, no, the IOCL may be given some time to decide the representation, combined as much as there are some facts which which are required to be gone into. Okay. On considering the fact that the petitioner's representation has not been decided by the respondents number 23, this court directs the respondents number 23 to take a decision on the petitioner's representation dated 17/10/2024 within a period of
1 week, my lord.
1 week. From tomorrow you have got then 1 week. 1 week is today is what, Thursday.
Next Friday.
Next Friday is all Diwali. That thing.
Then Wednesday, my lord, because this is under active consideration, or I have taken.
Okay, when do you want?
Wednesday, my lord. By Wednesday, we'll discuss.
Within 1 week. Within 1 week from today. Within 1 week from today. Full stop. Till a decision. No.
Let there be status quo, my lord, till that date.
Status quo shall be maintained till the next day.
What they will do is they will interpret it as, will.
It may not, it may not, it may not.
They will say the status quo will mean that we will review soon.
Okay, list the matter on. When? No. Fourth. List the matter on 4th. Comma. List the matter of 4th.
Till then, let them supply it. Otherwise, I'll be on the streets. I have already.
You give him the Diwali time, he needs some money also.
I think that is a very fair submission.
Ah.
They will have all.
Till then, the IOCL are directed to ensure that a regular supply of oil is given to the petitioner
On payment, my lord.
On
on payment.
All right.
No one appears for the petition on call. No one had appeared for the petition on the last date also. In view of the above, the matter, but the writ petition has been filed in the year 2006. As there is no representation on the part of the petitioner, it appears that the petitioner is not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution.
30 and 31.
May I please your lordship, I'm on behalf of APDCL, the instruction are still waited on.
My God,
from the
instruction,
council,
huh? Instruction.
That's the way the issue.
Okay, yes, oh, yeah, 2024, yes,
Yes, 29.
okay,
Petition in 2024, but the issue involved with, since 2018.
right, Mr.
Sipol on behalf of KP Bhatt.
And you are Mr. Mr. M. Saki appears for the petitioner. Mr. Sri Paul,
Sipol,
C. Paul appearing on behalf of Mr.
KP Bhatt.
KP Pathak. Counsel for the respondent
Number 2, 3, 4, 5 and 6.
2 to 6 submits that instructions have not been received. He accordingly pays for time.
Can
Yes.
you keep it as the last chance, because the 5 is on a day.
24 matter,
Madam, she, 2018, therefore, I am saying, so, because they not required to start the document, so all are ready, because I am against the order of the village.
APDCL has to do. APDCL has to file the affidavit, correct?
Your lordship, it may fix after 3 weeks.
Okay, last chance.
No.
Last chance is provided to the respondents to file their affidavit. This is the matter, give after 4 weeks. List the matter after 4 weeks.
Much obliged.
32.
No affidavit, then what to do? Ms. S. Bora is not here also. Who is-
Before the second why is concerned, we have taken custody, but he has not appeared and he is not interested to execute the order. Therefore, what I'm respectful submission to you. Let the watching the disposal will take direction to the responsible authorities, where cannot the accept work, because this is a public utility.
Let the authority decide that, not you.
Not lordship, if your lordship directs them. Because he is not executing since 21/7/23, the 21/23 work order was issued. Already more than 1 year now. Lordship order in page, 24.
Yes, what is to be done, madam? No point adjourning all the time.
Nobody can do it.
Huh?
Also, Mr. Esbora even dates, he has not received instructions yet.
This is a very small issue. Whether
Madam, that is a bit totally clear.
right, Mr. S. Bora, learned standing counsel, Miss
J. Rajkumari.
J. Rajkumari appearing for Mr. S. Bora, learned standing counsel BTC. Submits that no instructions have been received by the council till date. Last chance is provided to Mr. S. Bora, learned standing counsel BTC to obtain instructions and file affidavit. Puस्तक. No, in terms of the order dated 26/7/2024, notice has been deemed to be served upon the respondent number 5. Lists the matter on give a date after 3 weeks. Comma, failing which, this is the matter on said so. In the event no instructions are forthcoming, comma, the personal appearance of the concerned officer may be called for. You please answer the question. Cannot be like that. We'll call, you tell your senior, we are going to call your officer.
In this case, actually, instruction has to be come from deputy commissioner. The last order, it was wrongly reflected from the myself lordship.
Yes, Mr. Chetya, what to do?
We have not received any instruction from them.
From the DC?
Yes.
So one thing here, whole fisheries, but there is, we have finally visible. That is pending. Can you dispose of which directing them
To the deputy commissioner to dispose.
and the preliminary is the next one that it's at 6.
Regarding extension of this.
And,
Like it's right or not. That will be. Right.
energy was issued, but no settlement is regular. No order is given for, now they are claiming that the money is. Was ordered. But you go to the hospital. Like,
2019 NIT. Huh? For 5 years. That has ended. So it's a question of extension.
Actually, we don't, but other parts of the refund of money, I have not taken any position. There are no settlement order issued to me. And I'm not, may,
Correct. Actually, this is wrong also.
now they are issuing like before you did other area.
So you want your representation dated 12/4/23 to be decided.
Fine.
But settlement cannot be given now.
I am also not, let them issue credit settlement, not credit like
Let me see your representation. Says that.
base 23. And
But your prayer is for to allow you to catch fish for 1 year, 3 months.
City of Rashid, I paid there, but that was not given to me. I just filed it.
No, but then you want this representation to be decided.
Yes.
How can it be?
Let the disciplinary file their formula.
And out here you said 11/4. It is 12/4 out here. And then you can file a fresh representation
Yes.
with regard to return of your kiss money.
Yes, madam.
And if it is formula, we file
Huh?
it, then it will be considered as, yes.
Yes.
I do.
You file a fresh. Fine. Heard Mr. A. Rashid, learned counsel for the petitioner. Also heard Mr. M. Chetia for the respondent number
2 and 3, madam.
2 and 3. And Mr. P. Sharma for the respondent number 1. Is it?
Yes, sir.
Pushkar. The counsel for the petitioner submits to take from this order dated 22/3/2024, second line, it submits, it's here, the second line. Okay, then next paragraph, okay. Then first paragraph. Mr. A. Rashid submits that as the validity period of the fishery has expired. Correct?
Right.
Has expired, comma. The petitioner's only prayer at this stage is for return of his deposited kiss money.
And installment,
And
and 2 installment. At the rate of 2,000. 250. I have mentioned that paragraph 4.
and refund of call deposit. Kiss money, whether it was 2 installments or 3 installments, how does it?
Yes.
And the refund of call deposit. Pushkar. Mr. M. Chetia, the learned counsel for, the counsel for the respondents submit that they have got no objection. No, no. No, I'll direct them. Hold it.
Yes,
You,
on filing an application,
huh?
on filing an application for returning the case.
The petitioner's counsel submits that the writ petition, that the writ petitioner may be allowed to submit a fresh representation to the respondent number
Number 2.
2 with respect to the above, which may, and a direction may be issued to the respondent number 2 to decide the said representation within a specified time period. Mr. M. Chetia, that counsel for the respondent number 2 and 3, and Mr. P. Sharma, that counsel for the respondent number 1, submit that they have got no objection to the prayer made by the counsel for the petition. Next paragraph. On considering the submission of the petitioner's counsel, comma, this court is of the view that the prayer should be allowed. Accordingly, the petitioner is given the liberty to submit a representation to the respondent number 2 with regard to refund of his kissed money, which he submitted in 2 installments, plus the refund of his call deposit. The representation should be submitted within a period of 2 weeks. Period of 2 weeks from today, along with a copy of this order. In the event, the respondent number 2 shall thereafter take a decision on the petitioner's representation. And if he comes to a decision that the petitioner has submitted the kiss money in 2 installments and finds that the call deposit has not been refunded to the petitioner, the same should be returned to the petition.
If he is entitled.
Full stop. The same is subject to the condition that the fishery had not been subject to the condition that the possession of the fishery had not been settled, had not been given to the petitioner, despite settling the same with the petition. Despite, huh? That's right. There was no settlement.
He submits whether that settlement is there or not. I cannot give it.
If settlement is not there, how did you pay his money?
The official, we have paid money that I do everything for them.
No. I think wait. I think what have I said? No, because just said after Chetia does not, they do not object, yes, right? On considering the submission made by the counsel for the parties, the petitioner is given the liberty to submit a fresh representation to the respondent number 2 with regard to his grievance. The representation should be submitted within a period of 2 weeks from today, along with a copy of this order. If the respondent number 2 comes to a finding that the petitioner is entitled to refund of, is entitled to payment of any amount as claimed by the petitioner, the said should be refunded to the petitioner within a further period of 1 month. The writ petition is accordingly disposed of.
2 months, my bad.
2 months.
Yeah.
No, 1 month. If you have really taken the money, you
On the order which part the deputy governor, that one putting in subject.
no, you do whatever. No.
34.
Same.
Same similar. Never the particular number.
Okay, out here same that same paragraph is there. Okay, same thing. Amount, everything.
35.
Yes, no, yes.
Yes, my lord, we have received instruction on that file an application.
What is, to what effect? You have admitted.
Admitted, my lord. send to the sanctioning authority for this matter.
Okay, Mr. M. Chetia, Learned Counsel for the respondent submits that as per instructions received by him, the amount claimed by the petitioner has been admitted and a proposal has been sent to the higher authorities for sanction of the amount. He submits that he may be allowed to submit the instructions by way of an affidavit. Praise allowed. This is the matter after.
Thieves, matter thieves.
I was looking at him. Yes, yeah. It reminded me of these actors of Bollywood. No? Yes, literally begging you. This is the matter after 3 weeks.
Okay, 6.
Dear Lordship, instructions received, Lordship. Affidavit has not filed. The amount is admitted, Lordship.
Admitted.
Admitted.
So you file a affidavit.
Affidavit.
Let him file affidavit, better.
If I may kindly take in watching.
38.
The report total circular, physical verification of the things.
Okay, 38. Okay. No, it just makes it more solid for you. That's it. Why? You'll take a lot of time.
Lordship. Yes, Lordship.
Out of 63 lakhs, 63 odd lakhs, 10 lakhs has already been paid recently. And 53 means. Fresh advisory has been said that page 39.
It does not say 3 lakhs, page 39. Where does it say 10 lakhs have been paid? Nothing, nowhere.
Lordship, second line of the report. Some of the 63 lakhs, 32,400.
Yes.
Is pending payment, Lordship. Then in 39, Lordship, with sufficient of fresh advice leave for release of payments. This is an amount of 53 lakhs, 32,450. Out of this, it's 63 10 lakhs has been paid. And earlier, Lordship, they have paid 2 crores 96 lakhs. 12,100.
So how much are you supposed to pay, madam? Now, as
Yeah.
per your instructions?
As per my instruction, 53 lakhs, 32,450.
Should we dispose of as per that or you file affidavit? What?
Then Lordship, Tamserali.
Huh?
Tamserali shall we follow Lordship because there are so many pending cases of.
Let her file affidavit. It'll be to your advantage. You will not get anyway. Because you'll be most probably at serial number 1,200 or something like that.
This is not, this is separate law. The fifth Assam state.
When can you file your affidavit?
This is fifth Assam finance.
2 weeks Lordship at least.
Let her file just.
This is not SOPD file, OCD. This is all fifth Assam state.
No, I'm just saying because supposing there is a problem later on, then
This is separate law, not CD file, not SOPD.
Then also
Whatever
Lordship,
it is.
Tamserali will follow Lordship. There will be some other persons also in queue.
The considerably, it is not come law, the way.
I'm not on that. Yeah, so it's like you have seen some food and you want to eat it. It's not that. Now you see, the thing is that if they file affidavit, then they cannot now later say that this is disputed. Only on that count. So that my order also, it cannot be challenged. Because tomorrow they'll take a different stand. You don't know. BTC might take a different stand tomorrow. That officer is not authorized to say that. This is a false statement. So once the affidavit comes, then Miss R.B. Bora, otherwise I can dispose of, no problem. It'll be disposal for me. It's very easy. Not a problem. Miss R.B. Bora submits that she has received para-wise instructions to the effect.
Instruction.
She has received instructions to the effect that rupees 53,32,415 is payable to the petitioner. She submits that she will file an affidavit.
Additional chief engineer from direct.
No, it's okay. She submits that she will file an affidavit to that effect within 2 weeks. List the matter on. Madam, please, will you file it?
I will.
Not I will try. When you say 2 weeks, you've got to file within 2 weeks.
Then 3 weeks. Lordship.
No, it's not that. Whether 3 weeks, 4 weeks, no. The thing is that this is an admitted amount.
Lordship, it is communication to the secretary by the chief engineer. Kindly
That is what Let them file affidavit.
Okay.
Let the matter on 18th. So 18 means 3 weeks.
Lord,
Yes,
18.
3 weeks.
18.
That is 3 weeks. Yeah,
if you,
3 weeks time, huh? Then 18. Let the matter on 18th.
If then no affidavits come forward.
If no affidavit, then we'll dispose of as per.
37 for orders.
Yes.
I think the issued e-challan that will be imposed against me.
What are you challenging?
Issued e-challan.
Why?
Because I think that some of the, I think that they were arbitrary. In the clandestine manner, they were imposed upon.
Who are you?
I have a,
The challenge were issued to you.
yes, my lord. I have a partnership firm, my lord, which is into the business of trucks, my lord, transportation business. We operate trucks. So during the course.
How many e-challange were given to various trucks?
Yes.
In various places, my lord, these are all e-challans of old e-challans, my lord.
Okay.
They're from 21, 22. They can take the alternate refund judicial mechanism. A similar case, my lord has
Uh-huh.
decided.
May I kindly submit?
Yes,
My lord, may kindly peruse the last order dated 18/9/24 by this.
yes.
My lord, kindly, observation. I have made certain categorical aberrations. My lord, the.
This is a writ court, Mr. Kaur. E-challenge and all. What?
My lord,
Challenge the e-challenge.
my lord, may I please submit? My lord, kindly peruse the honest note dated 18/10/20.
I have perused. You have not taken steps, usual process.
My lord, it's not I think, my lord, usual process also may be allowed. My lord, the officers will impose the challenge.
I'm not on that.
Give their stand. Because they have done it right. And there are certain lacunas on their part because of which I'm challenging the state challenge. My lord, kindly appreciate my lord, section 194E, which talks about wearing of protective headgear has been imposed upon me. My lord, these are truck drivers. It is not possible. My lord, it is out of question,
Paragraph
my
number
lord.
10, my lord.
Apart from that, my lord, section 192A, which talks about vehicles without permit, whereas I have got all the permits, my lord. My lord, if I may kindly demonstrate for a moment, with this honorable court's permission. These are my grievances, my lord, that is why.
E-challenge, you cannot file cases of e-challenge in this court.
But as per the SOP, my lord, I am handicapped, my lord. What the department has, my lord, may kindly peruse this SOP, my lord, for. I may kindly.
I'll make see paragraph number 10, my lord.
Paragraph 10.
10, my lord. Let me read. My lord, coordinate bench is also make the similar observation.
You kindly refer to the SOP, my lord, and page 3 of the SOP. So kindly refer. My lord, it talks about the last, my lord, that has to be paid online.
You have not, huh? You have not given page 2 and 3. You have given page 1, 4.
2 points.
No, these are, these are, writ court cannot be bothered with this thing, traffic challenge and all.
There is a handicap.
Right, heard
We have seen
Mr. P.R. Sharma, Learned Counsel for the petition. Also heard Mr.
R.B. Goswami on behalf of Assembly Board. R.P. Goswami,
R.P. Goswami on behalf of
Miss M.D. Bora,
NB Bora. This
Respondent
MD Bora.
Yes.
Learned counsel for the,
respondent number 2 and 3, ma'am.
that's point number 20. Goswami. Do you take this in the order dated 18/9/2024? Huh. The petitioner's case is that series of e-challans have been issued. And then you carry on, okay, in this para 1, 2, 3, 4, okay. A perusal of the, no, first up. He submits that the offense with which the petitioner's vehicles have been charged with cannot be proved and the fact and that the impugned e-challan lacks any remarks which would make it clear by which act the petitioner's vehicles have been charged with. Mr. R.P. Goswami, learned counsel for the respondents on the other hand submit that as there is an alternative remedy available, that is
They can file an appeal with the grievance redressal mechanism of
by filing an appeal before the
grievance
in the
redressal-
portal,
Yes, my lord, it's a portal. Of law.
filing an appeal. That is by filing an appeal in the grievance redressal system in the portal opened by the Ministry of Road Transport Department and Highways. The writ petition should be dismissed. Should be dismissed. First up. But what were the charges out here against the petitioners? David,
There are
what were the
different ones,
charges?
my lord. There are many e-challans in different districts.
Yes, yes, just show me one, say page 343.
340. My lord, this is once, section 179(1), disobedience of order of authority. My lord, we see page like, my lord, we see page 191.
allowing unauthorized person to fly.
Ninety paid 193 for 193. That's cool. Minus 194 D of trading of helmet file. These are tax file. Question doesn't arise. And the document which.
So then you go in the appeal provision, that's what. We cannot go into the writ court, don't expect them to go into wearing of helmet, disobedience of superior officer. No, no, right. I have heard the causes for the parties. First now, on a perusal of the e-challans that have been issued to the trucks being run by the petitioner company, comma, this court finds that they have been issued for overspeeding, comma, disobedience of the order of the authorities, disobedience with not complying with the traffic signals, comma, non-functioning of reflectors,
Is driving without seat belt.
huh?
Is driving without seat belt.
Driving without seat belts, comma, driving by unauthorized persons. Full stop. In page 193, you said, no? In page 193, the charge is that is charges of riding without helmets by both driver and pillion. Full stop. Next para. As can be seen from the above, as can be seen from the numerous challans involving how many trucks? Involving, and how many challans are here?
It's
Hundreds, 200.
must be another.
Huh?
More than 50 minus.
What is more than 50? More than that.
More than that. It's at least 200 minutes. Start from 109.
That's what I'm looking from 184, I think. 184 to 344. That means on considering, what have I said? That have been annexed to the numerous challans that have been annexed to the writ petition. That is more than 150 challans involving various trucks belonging to being operated by the petitioner. Comma. The issues are basically with regard to disobedience with the provisions of the Motor Vehicles Act. Motor Vehicles Act and the Motor Vehicle Rules. Motor Vehicles Act 1988 and the rules. Though the petitioner has tried to make out a case that though it is quite apparent that there has been a mistake in respect of one challan, that is at page 193, wherein the driver has been charged with driving the truck without a helmet, comma. This court does not find any reason to interfere in the said order, inasmuch as the same can be put to challenge before the appropriate authority. There being a efficacious alternative remedy available, the same can be put to challenge therein. Or else, the writ court would be flooded with cases involving e-challan every day. The number of e-challans cases in the state of Assam is around, we take it from, is around dash per day. We take it from the CJM's court. As such, this court is of the view that when there is an alternative remedy available involving violation of traffic signals, not driving of vehicles by unauthorized persons, driving without seat belts and license, the challenge to the same, which involves disputed questions of fact, would have to be taken up by the efficacious alternative remedy available. First up, this would be in consonance with the order dated 14/6/2024, passed in WPC 3039 of 2024, and order dated 19/6/2024, passed in WPC 3059 of 2024, wherein this court refused to entertain cases involving traffic e-challans. First up, on account of an alternative remedy being available. So accordingly, due to the reasons stated above, this court is not inclined to entertain the writ petition. The writ petition is accordingly dismissed. You cannot expect to have the Evidence Act, that those things are all in this e-challan cases. You go to the alternative remedy. To this. Item?
I have not received a copy to President. Oh, that's enough. Okay. That's it, I will take the copy.
From the very day of the order. But in the office now, they stand only on 15/10 night.
Anyway, I'm here, Lordship, no issue. We have to take steps on me, Lordship, right? Lordship, it's a 40% fishery, so. Private experience. Private experience, na? Wo part to kaisa na?
You have notice sent to 3 to 7 on 23/10 or 5/10, 15/10. 15/10, so not even,
I have taken on the very day.
To me only. No, but you don't.
but sent just recently, so we have to wait,
Yes, it's a date, Lordship.
right? Petitioner's counsel is present. Mr. P. Sharma appears on behalf of respondents number.
1.
Respondent number 1. Well, Mr. K. Goy appears on behalf of respondent numbers
2, 5, 6 Lordship, 2, 5 and 6 Lordship.
2, 5 and 6. No one appears on behalf of respondents number 3 to 7, 3, 4 and 7. Though notice was issued to them on 15/10/2024. As now accordingly, await service report on respondents number 3, 4 and 7. List the matter after 2 weeks.
In the 58,
Give a date.
Lordship.
39.
Mr. Sharma, please meet me after the thing. Okay?
Pursuant to your Lordship's direction, I have filed an affidavit on behalf of the respondent number, my lord, 4. Now, in fact, there is an inquiry report also.
Is it here?
Yes, my lord, I have on the.
Okay, yeah.
Yes, my lord, in fact, what has, my lord, transpired, my lord, in fact, subject to what my learned friend says, now from the inquiry report, my lord, there are certain factual disputes, perhaps which cannot be decided by your lordships. And on the basis of that inquiry report, the ARCS has refused, my lord, to approve the resolution of the board. Now, that refusal, it gives a cause of action to them
Correct.
to file an appeal before the registrar. So if he agrees, my lord, they may file an appeal against the refusal and inquiry report. That can be done before the registrar, my lord.
Yeah, you know, we have filed a petition. And we have came to learn that it is taken. So that may be disposed of, you know.
So this can be disposed of.
Yes.
Your representation has been, where is the representation?
Yes.
No, but then you have to challenge this also. This is page, this P2 or R2.
Yes, my lord. That
This
is why
R2 has to be challenged.
R3, my lord,
R2,
R3, R3,
R-
page 40, my
R3,
lord. Page
R3.
40.
R3 has to be challenged.
Inquiry report, yes.
And therefore, only your lordship, I am saying your lordship, if their matter is.
Huh?
If their matter will taken up by the registrar, your lordship, and we have already given one representation. And the basis for that.
No, you file a fresh representation because you have got to challenge this. Okay. Right. Heard Mr. A.M. Khan, Direct Counsel for the petitioners, and Mr.
SK Taluk,
S.K. Talukdar for
1, 2, 3, 4, my lord.
1, 2, 3, 4.
My lord, your lordship will dispense, my lord, the service of 5, 6, and 7. And at the time of hearing, they will be called, my lord, because they are
Ah.
stakeholders.
That's that, right. The case of the petitioners is that the Assistant Registrar of Cooperative Societies, bracket ARCS, that close, comma, Barpita, has not given his approval to the resolutions passed by the Board of Directors on 16/8/2024. The petitioners pray that the ARCS should either approve the resolutions or give reasons for not approving the same. Mr. S.K. Talukdar, the learned counsel for the respondent number 4,
1, 2, 3, 4.
1, 2, 3, 4, submits that the
ARCS
ARCS has rejected,
in fact, your lordship will say refused, but to
has
approve,
refused to approve
my lord.
the resolution passed by the Board of Directors on 16/8/2024.
In view of the inquiry report, my lord, at Annexure R3, man.
In view of the inquiry report dated
29 August 24, man.
29, 29/8/2024.
Yes, man. That
Issued by
my lord, the inquiry officer, my lord, at page
Issued-
42.
issued by the
Inquiry officer.
inquiry officer.
Right.
Pusta. He accordingly submits that a challenge would have to be made to the inquiry report by the petitioners before the Registrar of Cooperative Societies.
Yes.
Next column. Mr. A.M. Khan, Learned Counsel for the petitioners, submits that in view of the inquiry report dated 29/8/2024, he would like to withdraw this writ petition with liberty being given to him to file an appeal before the Registrar of Cooperative Societies. The prayer of the petitioner's counsel is allowed. The writ petition is closed as withdrawn, with liberty being given to the petitioner to challenge the inquiry report dated 29/8/2024 before the Registrar of Cooperative Societies. The writ petition is accordingly disposed of.
Lordship will, my lord, make it clear, 5, 6, and 7, my lord, their service.
Acha, in the event the petitioner submit an appeal, comma, the respondents, the Registrar of Cooperative Societies shall ensure that an opportunity of hearing is provided to the respondents number 5, 6, and 7 before taking a decision on the petitioner's appeal. Finish.